Peace, 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 everyone. Grand Rising, Grand Tuesday Rising, Freedom Riders. Your girl, Empress ShayMarie. I'm back for another video. Hope everyone has had a lovely past few days. Welcome everyone. Thank you for the likes. Thank you for joining me. Thank you all. I see y'all coming in with them likes. Y'all doing the damn thing. I see. Grand Rising to everyone. Peace and love. I do apologize. I apologize for my absence last week, you guys. I ask that you please forgive me. As you know, we all go through things in life or whatever that sometimes, kind of stop the flow of things. But I'm still doing good. I'm still pushing on. I thank you all. I thank each and every last one of you for your support. Grand Rising, Brother Willie Rivers. I'm doing pretty good, thank you. How about yourself? So I'm back to keep my word, you guys. I know we were supposed to start this book last week, but life got in the way. So here I am. Today's a new day. Make sure y'all hit those like buttons, share this video. We're going to be reading about asset protection and pure trust organizations. Okay. I wanted to make a couple announcements. If you're watching or you're listening, if you reached out to me by email or on Telegram or Facebook, those are the three ways that you can definitely get in touch with me: email, Facebook, and Telegram. And all of those communication links and everything are in the description area of the video. I do private consultations, but more so, I'm all about building community and, unifying with my people. So we do have a community, a very fast growing community, called Freedom Riders, and we, communicating everything on Telegram. So if you'd like to join the Telegram group, there is a screening process. I do need to know who you are. I need to see your face. I need to, have an NDA signed, a non-disclosure agreement. And then you're able to be let in once I approve of you being allowed in my group or whatever. I'm looking for serious people. I'm not looking for anyone that's just wanting to sit around or that's not going to participate. I love participatory. We have classes on Tuesdays and Thursdays. We do meditation on Wednesdays. All of them are at 6 p.m. on Eastern Standard Time. And we have fun. We have a lot of fun. I am enjoying, getting to know each and every last one of my members that have joined us over the past couple of weeks. We're a growing family. And then those that join Freedom Riders get an extra perk. We have my very close friend and person that has been over the last year, studying and growing with me in this knowledge, Mother Mia Shay L, who does she does her grow, show, and know class, and she's showing us how to grow foods, you guys. and the nutritionist of them. She's teaching us a whole lot, just how to be prepared for the worst. And so we have a lot of fun um, in that class as well. We do participatory things such as planting our seeds together and things like that. So it's been real exciting and real fun. It's a great opportunity and great thing where you can bring your children and have them sit in and watch and learn and participate as well. So I highly recommend, don't sleep on Freedom Riders. Don't sleep on joining the community. So that we got 11 people in the building. I need to see 11 likes because I like that 1111. So let's see here. Miss Expressive, Grand Rising. I'm in. I want to be a part of this. Okay, well, reach out to me, email me, or follow me on Facebook. Reach out to me on Facebook or on Telegram. Um, all of the links and ways to get in touch with me are in the description of the video, you guys. So that's how you can do that. And then we'll get you on the way, get you screened and processed and everything. So I'm going to go ahead and start reading, and we'll go from there. So, Asset Protection, Pure Trust Organizations. This book was written by David E. Robinson. As you guys have probably noticed, a lot of the books I've read are by David E. Robinson. Copyright is from 2011. It says God gives you his ideas, and they in turn give you daily supplies. Okay. Introductions, appendix. Okay, so introduction. Advantages of a pure trust. Knowledge is the power of the global community. For those who consider confidentiality, vitality important, trust offers privacy, protection, and profit. A trust provides the first step towards total privacy. With a trust can conduct banking anywhere in the world. International banking provides the most ideal method for receiving profits, but only through a trust. What can this trust do for you? 1. Assets are protected 100%. The number one enemy in the world is litigation. Protection from creditors is 2. You have 3, protection from liability suits. 4, protection from malpractice suits. 5, protection from employees. 6, protection from personal bankruptcy. 7, protection from excessive divorce settlements. 8, avoid probate. 9, avoids inheritance tax. 10, avoids estate taxes. 11, avoids court actions. 12, eliminates attorney fees. 13, eliminates or reduces accountant fees. 14, eliminates executor fees. 15, eliminates or reduces income taxes. 16, frees tax dollars for capital appreciation. 17, provides complete control over assets through trustees. 18, no public record. 19, ownership and title can be passed to heirs in complete secrecy. 20, trust is perpetual. The trust lives on continuously. 21, heirs cannot change, challenge, or contest any wishes at your passing on. The trust is easy to maintain and very expensive. All right. Chapter 1, Principles of a Trust. The people perish for the lack of knowledge. Hosea 4 and 6. No state shall pass any bill of attainder, ex post facto law, or law impairing the obligation of contract. The Constitution of the United States, Article 1, Section 10. The citizens of each state shall be entitled to all privileges and immunities of citizens in several states. The Constitution of the United States, Article 4, Section 2, Clause 1. The properly structured pure trust organization provides the quickest and simplest legal road to freedom, creating the ultimate in tax immunity and ironclad asset protection. By transferring assets into properly structured and legally recognized pure trust organizations, you are able to maintain complete control of all the benefits of asset ownership without the inherent liabilities. Because the assets are held in trust, they cannot be liened, seized, or levied for the debts of the trustees or its beneficiaries. Further, the trustees and the beneficiaries are not liable for debts of the pure trust. American citizens have the unlimited freedom to hold, transfer, sell, or dispose of their property in any manner they desire. It is neither unethical or unlawful to intelligently protect your family's property and your family to legally and intelligently preserve what you have worked a lifetime to obtain. Pure trust organizations have been utilized by wealthy, financially sophisticated Americans for hundreds of years. Transferring assets into a properly structured pure trust organization is as easy as transferring property to another person. Asset can be conveyed into a trust even if an erroneous notice of lien has been filed against the property. As confirmed by the Chief of Accounting of the IRS, a pure trust has no tax requirements. Therefore, there are no legal requirements for a pure trust organization to file a tax return. Since the business trust has its origin in the common law right of the parties to enter into contract and does not spring from a franchise granted by the state, it has been held that the constitutional authority of levy excises upon commodities income tax, a term including corporate franchises, does not empower the legislator to impose an excise privilege tax on business trust. 266 Mass 590 163 NE 90 blah 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 blah. The courts ruled that a pure trust is not illegal even if formed for the express purpose of reducing or avoiding taxes. Okay? The courts ruled that persons may adopt any lawful means for lessening the burden of income tax. Edison, California, Stores Inc. versus McCogan, 30 Cal. Okay. Avoidance of tax is not a criminal offense. The Department of the Treasury IRS Handbook for Special Agents, number 4112, tax avoidance distinguished from evasion. Any attempt to reduce, avoid, minimize, or alleviate taxes by legitimate means is permissible. It is not an evasion of legal responsibility to take what advantage may accrue from the choice of any particular form of organization permitted by law. Narragansett Mutual Funds Insurance Company versus Burnham, 51R 1372 154 A909. Never in the history of America has the need for property and asset protection been greater. It is a stark reality in today's world that a sudden financial reversal, an unanticipated lawsuit, or the stroke of a bureaucrat's pen can overnight wipe out a lifetime of accumulated savings and assets. Regulatory assaults on probate property are at an all-time high. Under recently passed asset forfeiture laws, the government can seize probate property for minor third-party offenses of which the property owner may not even be aware. This can create costly legal expenses and tie up time in court, even if the owner is innocent. The peer trust organization is a powerful tool which can be held to protect a citizen's property from the myriad of regulatory abuses imposed by the government as well as frivolous lawsuits. Also, in today's corrupted and technological super communication age, your privacy can be invaded with the stroke of a keyboard. With a citizen's social security number or federal ID number, personal information can easily be discovered that can fraudulently be used to abuse their credit and misappropriate their assets. Because the peer trust organization is lawfully established and bank accounts are opened in a fictitious name without a social security or a federal identification number, paper trails to the citizen are permanently severed. Most Americans do not realize that they have a choice of laws when conducting their personal and or business affairs. Rarely do we hear about the legally recognized American common law, which is the people's law, created by and for them. The common law existed long before statutory law and is as viable today as it was in the beginning of our country's history. Originally, the common law was created to protect the rights and property of the people against the abuses of the sovereign king. Unfortunately, today, the common law trust is seldom utilized to protect the people's property against the abuses of our current government. In America, the people are sovereign and may choose to legally conduct their affairs outside of government regulation under the common law. Statutory law is a creation of the government for the purposes of regulating, fining, and penalizing the people. Although it is in the best interest of attorneys, CPAs, and the government to promote statutory trusts, which are a creature of the legislator and therefore have strategic, regulatory, and tax requirements, this type of trust is the most inhibiting for the citizens or for the citizen. Statutory trusts provide only limited protection for property and truckload of paperwork and taxes for the citizen. The statutory trust is referred to as a revocable living trust or grantor trust and is required to file a 1041 form every year, whereas the common law in America is law based upon the principles of justice and reason. Under the common law, as long as a citizen do not infringe upon the rights of others and keep all agreements entered into knowingly, intentionally, and voluntarily, they are absolutely free to legally conduct their lives and or businesses in any manner they choose. Grand Rising, honey. Under the common law, an American citizen cannot be compelled to do anything against his or her consent. The common law trust, being a creature of our constitutional right to contract, has no government regulations, no tax liability, and is not legally required to file a tax return. To put it simply, the Internal Revenue Service and other agencies of the government have no jurisdiction over common law pure trust organizations. It is American free enterprise in its purest form. All right. You guys, I forgot. Next time I come on, I just remember next time, I do have this on a PDF where it will be easier for us to read together instead of me having to flip through these books. So I'll come on that way next time. So it says, Chapter 2, Financial Planning for the Future. Okay. The knowledgeable, the knowledgeable and wealthy have continued to utilize the pure trust throughout history, American history. When the original 13 colonies won their independence, the man who was reputed to be the richest in the nation, William Bingham, who also served as a senator from Pennsylvania in the Second United States Congress, started a pure contract trust for his estate, which at one time held over 2 million acres in Maine. Wow. After 160 years of operation, the trust was terminated in 1964 upon the sale of the last of the properties involved and because the number of beneficiaries had grown to over 300. During the trust's existence, however, it was not affected by the death of its creator or by the death of generations of trustees. It never paid a cent in probate costs or estate death taxes. The Kennedy family is known to maintain a number of pure trusts, a process which was begun when Joseph Kennedy created a pure trust to own the Chicago Merchandise Mart, which was valued according to Chicago Tribune article dated March 22nd, 1947 at some $30 million. Wow. William Walford Astor, saving his heirs millions of dollars in probate costs and estate taxes, created a $50 million trust estate. It is reported then when William John D. Rockefeller died, he had over 250 pure trusts. Rumor has it that the number of Rockefeller pure trusts now tops the 2,000 mark. The billion-dollar plus Mellon Bank, has extensively utilized the complex structure of pure trust organizations. The Dallas Morning News carefully researched the estate of Texas oil man H.L. Hunt, who died with less than 30,000 in total personal assets, automobiles valued at $21,250 plus $5,443 on deposit in his name in the bank. Yet he passed complete control of an estate estimated at 2 to 5 billion of dollars to his son. Wow. Bunker Hunt, without estate taxes or probate costs, through the use of pure trust organizations. Why are we utilizing the successful history of the knowledgeable and wealthy? The leading reason people are missing out on the best in trust is because the majority have done nothing in preparing to leave assets to their children. Most people feel that they have plenty of time and will eventually do what needs to be done. There are those who believe a good will, quote unquote, is all they need. Their lawyer, quote unquote, friend has convinced them that a will is the best option. There is no law that states that an estate has to go through probate, but a will mandates probate. Years ago, knowing that there was no way to stop trust from being used, lawyers arranged the legal system to where if you used a will or made a provision for distribution of your estate, then the estate had to go through probate. Wills were then promoted and trusts were ignored until the last 10 years or so. Chapter 3, Tax-Free Living. A family utilized a trust and transferred its assets, including house, car, and equipment used in the family business, a farm, to the trust. The family then entered into an employment contract with the trust, which required family members to live in the former house because their presence was required at all hours to manage the trust. The trust agreed to pay the family's living expenses, including lodging and food. The family took the payments tax-free because the arrangement benefited their employer, and the trust deducted its expenses. IRS ruling. The arrangement is proper even if it was adopted with the explicit intention of avoiding taxes. Source Letter Ruling 9134002. Okay. Chapter 4. Pure Trust Definitions. The corpus. The property held with the pure trust is called the corpus. One or more trustees manage the corpus for the benefit of an unlimited number of beneficiaries, capital unit holders. The exchanger or settler. The pure trust is implemented after it has been signed and executed by all parties to the contract, and the exchanger, who is called a settler, conveys property into it, creating the corpus of the trust in exchange for capital units. This constitutes a tax-free exchange. The exchanger can hold all capital units or divided them among beneficiaries of the exchanger's choice. The exchanger or settler can be a beneficiary capital unit holder or a capital unit holder, or only a capital unit holder. Beneficiaries, capital unit holders. Capital units represent 100% of the rights to the proceeds and the rights to the benefits of the property held in the trust. This is called the beneficial interest. This means that although the exchanger no longer owns the property, he retains the benefits. For example, if a car is in the trust, the beneficiary can drive the car. If a house is in the trust, he can sign a lease agreement with the trust and continue to live in the house. If a business is operating as a pure trust organization, the beneficiary capital holders have the right to the profits and proceeds of the business, etc. The beneficiaries of the trust are capital unit holders. A beneficiary capital unit holder has no management control of the trust. Management control is the responsibility of the trustees. For this reason, the trust is said to be pure, and the beneficiary capital unit holders are not liable for any obligations incurred by the trustees or managers appointed by the trustees. The trustees. The trustees do not own the property held in the corpus by the pure trust organization. They merely hold the property and manage it for the beneficiary capital unit holders. Pursuant to Hussey versus Arnold, 70 NE 87, Mayo versus Moritz, 24 NE 1083, even though the trustees hold property, that does not mean that the trustees own the property. Trust property cannot be held under an attachment nor sold for the execution of any trustee's debts. Trustees cannot be held liable for debts incurred by the trust. The trustees cannot, in addition, be beneficiary capital unit holders, but they can be paid and receive compensation for their function as trustees. Status of the Pure Trust Organization, PTO. The Pure Trust estate is irrevocable. This is not as intimidating as it sounds. A pure trust can buy, sell, or transfer property into and out of the pure trust estate like any other form of business, but you cannot move the property back and forth between you and the trust if it is to be pure. This is to your advantage because you would not want a crooked creditor to take you to court in order to force you to revoke the trust so that he can attach your property. Transferring property. Transferring property into a contract of trust is as simple as transferring it to any other third party. property is simply transferred from the original owner to the name of the trust. Okay? How y'all doing in the chat? Let's see. Greetings, everyone. Grand Rising. Okay. So let's keep on reading. Structuring the pure trust. Hold on one second, guys. All right. General structure of the pure trust. The pure trust is like any other person or business entity that has the power to hold, sell, or transfer property, conduct business, etc. It is simply an entity that has a different name and ID number than you. Property is transferred into the name of the pure trust as if it were any other person. Once title to the property is in the name of the trust organization, it is protected by the ironclad contractual and constitutional protections contained in the trust instrument document. Because your right to contract cannot be impaired, you have peace of mind and knowing that the property is safe and is safely protected. You will have the advantages of property ownership without the possible liabilities. Number of pure trusts needed for maximum asset protection. To maximize the benefits of the pure trust organization, it is vital to put each asset that has the potential for creating a liability into its own separate pure trust so that it does not jeopardize other assets. In a lawsuit, lien, levy, etc., the only asset that can be seized are those assets that are held in the name of the person or entity that created the liability. For example, let's say that your car was involved in a serious accident that created $1 million worth of damages, and the insurance company refused to honor your claim. Because your name was on the title to the car, if you are successfully sued, a judgment would be entered in your name. Therefore, every asset held in your name would be subject to seizure. A pure trust allows you to contractually move assets out of your name while still retaining full control and all of the benefits of the property. In the previous example, if you had had the forethought to put the title to the car in the name of a pure trust instead of in your name, only the pure trust could be sued under its fictitious name. The assets held in your name or in the names of other trusts would be immune from judgment. If a court judgment, lien, or levy has been filed against you personally, only those assets that you hold in your own name are subject to seizure. Wow. Businesses should always have a minimum of several pure trusts. The first operating entity should hold beneficial interests of other trusts. The other pure trusts should be established under different names to hold and protect all other assets of the business organization. Business property and equipment that has the potential of creating a liability should always be segregated into separate trusts. Naming the pure trust. Unless you are creating a family trust, do not use your last name or the word trust. Name your business as if it were a sole proprietorship. This will protect your privacy and will also make doing business and transferring property simpler. The trust identification number. Because a pure trust has no tax requirements, it has no need for a federal employer identification number or a social security number, which are necessary for tax reporting purposes only. Okay? The pure trust will be issued a 9-digit internally generated identification number for banking and identification purposes unrelated to taxes. The trust identification number is private and will not be linked to any federal or state government agency. It will be included on your final Pure Trust documents. Each trust will be issued a separate number. Naming trustees and beneficiaries. The most important rule to remember when structuring your pure trust is that you cannot be both a beneficiary or capital unit holder and a trustee at the same time. It is the complete separation of these two entities, beneficiary and trustee, that affords the pure trust its protections. If the same person who holds the legal and equitable title also has the beneficial interest or the right to proceeds, no trust has been created. The entity is then said to be operating as an alter ego or as a nominee of the trust. The protector. The protector has the power to terminate trustees and or appoint new trustees. The protector may also appoint successor trustees in the event that a trustee dies. A protector cannot have any other position in the pure trust. A protector can be anyone related to or unrelated to you. Trustees. Trustees hold the legal and equitable title to the property in trust for the benefit of the beneficiaries or capital unit holders. They do not, however, actually own the property. A trustee cannot also be a beneficiary capital unit holder. Trustees have no rights to the beneficial interest in the form of income and profits. However, they can receive a contractually agreed upon compensation in return for their trustee services. Trustees have management control of the pure trust. There can be one trustee or as many trustees as desired. All of the trustees can work together in managing the property, open and operate bank accounts, and take care of the day-to-day operations of the trust. Adversarial unrelated trustees. In order to maintain the tax immunity qualities of the pure trust, it is important that it is not considered a grantor trust, which is required to file a 1041 form. According to the IRS, the title of grantor trust arises when there is no trustee with adverse interest. The words adverse or adversarial means unrelated. The rule of structure is that the majority of trustees must have an interest adverse or unrelated to that of the beneficiaries or capital unit holders. This means that if the beneficiaries are your wife or husband or children, the majority of trustees cannot be related to them. Therefore, for example, if you were a man and wanted to be a trustee and make your wife and children beneficiaries, you must also have at least 3 other unrelated trustees. These trustees will delegate the authority to your managing trustee to open the bank account, sign checks, transfer property, sign the minutes, and make management decisions concerning the contract of trust. If you are not related to the beneficiaries, you do not need adversarial trustees. The managers. Typically, the manager will be responsible for the management of the trust. The manager is merely an employee of the pure trust and is not an integral part of it. However, some individuals choose this position because they want to manage the trust with privacy. When transferring title to real property and automobiles, it is necessary to include the names of the trustees in addition to the names of the pure trust as a matter of public record. The manager's names, however, would not appear on the title. It would only be included within the trust minutes, which are totally private. The beneficiary capital unit holders. Beneficiaries, capital unit holders, have the right to the beneficial interest, which is the right to the income, profits, and proceeds and use of the pure trust organization. However, in order to provide maximum asset protection, the trust must be pure. The trustee assigns capital units, which represent 100% of the beneficial interest of the pure trust, to the exchanger or settler in exchange for the property he or she conveys into the trust. The exchanger can then either keep all certificates or divide them in any manner among beneficiaries of his or her choice. Bank accounts. A pure trust can open a completely private account at a major bank with no federal ID or social security number. This account will be like any other checking account except it will be completely private. Illustration. To establish a pure trust, you, the exchanger, must exchange the title to your property, your house, your car, your business, etc., designated in capital units, and $25 weight of silver offered, received, and accepted in hand as consideration with the creator, protector of the trust, for 100% beneficial interest in the trust. It is tax-free equal value for equal value exchange. The creator or protector will then create an irrevocable pure trust and appoint you to be the director or trustee of the trust. You will then designate a successor to direct the trust in the event of your incapacity and appoint an adverse unrelated trustee or trustees whom the protector will have power to employ or discharge to manage the trust for the beneficiaries of your choice. The protector cannot have any other position in the pure trust, but he can be anyone outside the pure trust. The managing trustee can open a bank account in the name of the pure trust. If the beneficiaries are related to a trustee, the majority of trustees must be adversary unrelated trustees. Okay? So, questions and answers, Chapter 6 regarding pure trust organizations. What are pure trust organizations? The answer: a PTO is an entity formed by a contract that is capable of conducting any lawful business activity or operation, such as buying, selling, and holding property, etc. PTOs are governed according to the common law of contracts and are created by citizens exercising their unalienable, literally inalienable rights as recognized by the Declaration of Independence of 1776 and Article 1, Section 10 of the Constitution for the United States of America, 1787, which forbids our government from making any law which impairs the obligation of contracts. Unlike statutory trust entities such as the straw man, which are subject to the governmental regulation and taxation because they are created, registered, and regulated according to changeable congressional and state legislation, a pure trust organization is pure because it is untainted by outside influences. It is formed as a matter of a natural born human's sovereign, unalienable right to contract, a right which, again, may not be impaired in any way by governmental interference, regulation, or taxation. The contract creating the PTOs becomes its own law, the only law to which the PTO is subject. Not even the name given a PTO upon its creation must be registered with or approved by any governmental entity, no matter how many other entities may share the same name. Statutes that require persons or partnerships transacting businesses or business under a fictitious name to file a certificate giving the names and addresses of those making us or making use of such name to do. I'm sorry, let me restart this. Statutes that require persons or partnerships transacting business under a fictitious name to file a certificate giving the names and addresses of those making use of such name do not apply to business trusts that are in their nature pure trust and not partnerships. National City Finance Code versus Lewis. Okay. Business entities, sole proprietorships, partnerships, limited liability companies, joint ventures, corporations, and all but one type of trust organization derive their recognized form of existence from and through government, whereas the pure trust organization does not. Because it is an entity created by sovereigns exercising their natural, unalienable right to contract, it is not subject to governmental interference in any form. How do PTOs work? Step 1. You, as founder or trustor of a desired PTO contract with a creator protector for an exchange of property in return for the right to the final disposition of assets when and if the PTO is ever dissolved. This contract involves a quid pro quo equal value for equal value exchange. Step 2. Through the process of the exchange, the creator protector assigns your property to a fictional legal entity called a PTO. In the exchange, you offer and receive $25 of silver and consideration for 100% of the right to the final distribution of the assets and of the PTO when and if it is ever dissolved. Step 3. The creator protector will then appoint and employ you to be the managing trustee of the PTO, to administer the affairs of the PTO according to the terms of the contract. The creator protector must be someone not related to you by blood, marriage, or cohabitation. Step 4. You then designate the beneficiaries of the trust. Question. Why should $25 in silver be part of the exchange? Many people transfer assets to some entity for protection from taxation only to have the IRS come back and set aside the transfer because valuable consideration did not take place. Under the America's Constitution, valuable consideration occurs when the value of consideration is in excess of $20 of lawful money. When the value in consideration exceeds this amount, there is the right to a trial by jury in the event of a dispute, something not available in tax court. Note, as many of you know, the only lawful money in the United States are coins minted in silver or gold. This is specified in the original Constitution of 1787, as well as the current laws of the United States, 31 U.S.C. 5112. The paper currency that we use are Federal Reserve notes, and say on their face, this note is legal tender for all debts, public and private. Before silver coins were withdrawn from general circulation in the 1960s, they used to read, this note is legal tender for all debts, public and private, and is redeemable in lawful money. But in 1966, Congress passed the Federal Tax Lien Act. On page 3722 of that law, in a section subtitled Legislative History, Congress wrote these words: The entire taxing and monetary systems of the United States are hereby placed under the Uniform Commercial Code. This allowed lawful money to be totally withdrawn from circulation and replaced with legal tender. Under the UCC, there are four types of legal tender: cashier's checks, money orders, certificates of deposit, and promissory notes, but none of these is lawful money. What is an IEN? Most natural born Americans choose to obtain, they believe that they are required to obtain a Social Security number from the Social Security Administration. The IRS also uses this number for identification purposes. If this number is obtained from the IRS instead of the Social Security Administration, as is sometimes the case, it is referred to as a tax identification number or TIN. An employer identification number is a number that the IRS assigns to business entities, not nonprofit organizations, and public institutions, agencies that have tax requirements, employees, and an obligation to pay income or payroll related taxes and file reports with the IRS concerning those taxes. It's primarily used on tax returns and other reports with the IRS. Question: what tax requirements are currently being imposed on business entities, nonprofit organizations, and public institution agencies? There are several as follows. 1. The requirement to pay income taxes on income, profit, or capital gains. 2. The requirement to report on the distribution of income, profits to others, such as a sole proprietors, partners, shareholders, and beneficiaries. 3. The requirement to account for any pay for and pay to the IRS sums that were withheld for income tax, Social Security and Medicare from the salaries and wages of employees. Number 4, the requirement to account for and pay employer matching contributions such as Social Security and Medicare insurance for those employees who are participating in these programs. Number 5, the requirement to account for and pay other employee taxes such as federal unemployment insurance. Question: why doesn't a pure trust organization have tax requirements? PTOs have no tax requirements because they are sovereign entities, having been established as such under English common law and through the 200 plus years of American jurisprudence. Sovereigns are not subject to taxation and regulation. Subjects are. If we look at the history of trust, this distinction becomes clear. Trusts were a part of ancient Hebrew law. Around 400 BC, Plato used a trust to create a sovereign university in Greece. Trusts were also a part of Roman law. Jesus scolded the religious elite of his day for making a big show of generously pledging their assets upon death as a gift to the temple, a form of trust agreement that we'd call a charitable remainder trust, and then using that as an excuse for their private stinginess in not generously caring for their elderly parents. Wow. Trusts were used as early as the 11th century in the English-speaking world. By the 1400s, they were being enforced by the courts of chancery. The basis of English written law, however, dates to the Magna Carta of 1215, when knights who were wary of having the king take their lands when they went off to war persuaded King John to make this famous document. He wasn't happy about signing it because until then he was the only recognized sovereign in the land. But given the alternative of being beheaded if he didn't sign it, he saw the wisdom in recognizing that man, knights, and common man serfs is sovereign. Sovereigns can own land and are not subject to taxation. Subjects pay taxes. Common law trusts were soon established. Knights could choose to have their estates held by a separate party, such as a friend or the church. Property would be held in trust for the knight and his family. If the knight didn't return from battle, his family wasn't put out of the house and home. The knight may have died, but the trust as its own entity did not die. I'm sorry, the knight may have died, but the trust as its own entity did not die. If a knight was foolish enough not to put his property and estate in trust, many burdens would fall on the holder of legal title. For instance, if the son of the former owner was still a minor, the king had a right to claim fees. Also, if the property owner was ever convicted of a crime, he 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 would forfeit all that he owned to the king, leaving his family in poverty. Trust had many other advantages as well, including privacy. You may recall that the Revolutionary War was motivated in large part by what was perceived as oppressive taxation of the American colonies by the King of England and the swarms of agents sent to tax and harass the American people. In pursuing and establishing independence from the King of England, the American revolutionaries established that the sovereignty formerly held by the king and by lords, dukes, and knights belonged to we the people, to each of us individually, since we are endowed by our Creator with unalienable rights, and to all of us collectively who join together to form a more perfect union of sovereign independent republic states in which we reside as free, independent, sovereign citizens. Let's cross out that word, sovereign citizen. It's an oxymoron. All right. Patrick Henry was a patriot whose passionate paraphrasing, I know not what course other men may take, but as for me, give me liberty or give me death, inspired many during the days before the Revolutionary War. One day, Mr. Henry was approached by Robert Morris, governor of the Virginia colony, and a man who became a prominent financier of the American Revolution. Morris requested that Patrick Henry establish a trust for his property. King George was taxing property owned by any English subject, but he couldn't tax land owned by a sovereign or by a pure trust. The pure trust, which was created, the North American Land Company, is still in existence today. Wow. Question: why do the knowledgeable wealthy utilize pure trust organizations instead of wills, living trusts, and corporations? Answer: there are a number of reasons. 1. Because PTOs eliminate the estate shrinkage that is caused by probate costs and estate taxes. Wills are created in the expectation of death. Pure trusts are created in the expectation of life. A pure trust creator, beneficiary, or trustee may die, but the PTO does not die unless its trustees dissolve it. A trust for probate avoidance is a lawful, irrevocable, separate legal entity. Harwood versus Tracy, 118. 2. Because PTOs maintain complete personal and financial privacy, PTO documents and bank statements are not subject to IRS audit or other government subpoenas. The trustees of a trust have all the power necessary to carry out the obligations which they assume. Their books and records are not subject to review of subpoenas. Smith versus Morse, California, 524. Concerning privacy, a trust organization created under the United States Constitution's rights of contract cannot be abridged. Waterman versus McKenzie, 138 U.S. 252, 1981. A pure trust is established by contract, and any law or procedure in its operation denying or obstructing contract rights impairs contract obligations and is therefore a violation of the United States Constitution. Burnett versus Smith, 240 Southwest 1007, 1822 U.S. Supreme Court. 3. Because PTOs limit personal and business liability, if what you personally own at present is placed into a PTO, you will no longer own it. If you are sued and you lose, a judgment may only go against you and what you personally own. It cannot attack or attach itself to a PTO, which is a separately legal entity. Pure trust property cannot be held under attachment nor sold upon execution for the trustee's personal debts. Clue versus Jameson, 182 U.S. 461. 4. Because PTOs, as we have said, have no tax requirements, a pure trust is not illegal if formed for the express purpose of avoiding taxes. Edward versus Commissioner 415. Y'all getting some knowledge today. The legal right of a taxpayer to decrease the amount of what otherwise would be his taxes or otherwise avoid them by means which the law permits cannot be doubted. Justice George Sutherland Gregory versus Helvering, 239 U.S. 465, 469 in 1934. As to the astuteness of taxpayers in ordering their affairs so as to minimize taxes, we have said that the meaning of a line in the law is that you intentionally may go as close to it as you can if you do not pass it. Superior Oil Company versus Mississippi, 280 U.S. 390, 395, and 96. All subjects over which the sovereign power of the state extends, i.e., corporations or other statutory entities, are objects of taxation and regulation, but those over which it does not extend are exempt from taxation and exempt from regulation. This proposition may almost be pronounced as self-evident. The sovereignty of the state extends to everything which exists by its authority or its permission. McCullough versus Maryland, 4 Wheat 316. The pure trust derives no power, benefit, or privilege from any statute. Croker versus Malley, 264 U.S. 144. Gleason versus McKay, 134 Mass 419. Goldwater versus Oatman, 292 P 6224 from 1920. Because PTOs can engage in any lawful enterprise or activity, it is, quote, it has been held that public policy is not offended by permitting a business to be carried on by trustees who limit their liability to the trust estate, nor or do statutes authorizing limited liability partnerships and corporations by implication prohibit the creation of other types of organizations, such as a business trust, enjoying similar community by virtue of the common law. 14 American Jurisprudence 2D 6. Because PTOs may receive nominal income from any agents, trustees who have an employment contract with the PTO. This employment contract may provide that all income received from a firm, company, or individual for which or whom services have been rendered must be released to the PTO. Therefore, no government agency has the right to take income earned by the PTO in this manner, add it to the income of the trustees, and then force the trustees to pay income taxes on it. The Internal Revenue Service has recognized that amounts received by an agent on behalf of a principal and turned over to the principal are not taxable to the agent under Section 61A of the Code, Internal Revenue Ruling 76 through 479. The United States Supreme Court, Lucas versus Earl 281 UPS 111, 1930, held that tax responsibility can be shifted, not just the fruit or the income itself is conveyed. Moreover, under these circumstances, the third party employer cannot be held responsible for withholding income taxes. See IRS regulations. Okay. Number 7. Because if the trustee and or spouse signs a contract with the PTO that requires he, she, them to live and work on the premises in order to perform all of the services required, then such premises shall be supplied and maintained, all utilities shall be paid, and transportation shall be provided at no cost to the trustees, and the value of these items is not considered taxable income to the trustees. By, by the common law, every trustee has the duty of exercising responsible care in the custody of the fiduciary estate, unless he is relieved of such duty by agreement, statute, or order of court. U.S. ex rel. Willoughby versus Howard. Therefore, shall be excluded from gross income. There shall be excluded from gross income of an employee the value of any meals or lodging furnished to him by his employer, but only if a. In the case of meals, these are furnished on the business premises of the employer, or in the case of lodging, the employee is required to accept such lodging on the business premises of his employer as a condition of employment. Internal Revenue Code, Section 119. 8. Because PTOs have full sovereign rights guaranteed by the Constitution for the United States of America, 1787, and its articles in amendment, corporations and other business entities do not have such rights. The fact that a business trust is not regarded as a legal entity distinct from its trustees, if a true trust may result in disadvantage to the trust which a corporation does not possess, the trust consists of individuals who are citizens and who, therefore, are entitled to a certain rights and immunities such as those guaranteed by the Privileges and Immunities Clause, Article 4, Section 2, Clause 1 of the Federal Constitution, which do not apply to corporations. Morrissey et al., Trustees versus Commissioner. Okay. The individual may stand upon his constitutional rights as a citizen. Notice that citizen is spelled with a capital C. Okay. He is entitled to carry on his private business in his own way. His power to contract is unlimited. He owes no duty to the state to his neighbors to divulge his business or to open his doors to investigation. He owes no duties to the state since he receives nothing therefrom beyond the protection of his life and property. His rights are such as existed by the law of the land. long antecedent to the organization of the state, and can only be held or taken from him by due process of law and in accordance with the Constitution. He owes nothing to the public so long as he does not trespass upon their rights. Hell versus Hinkle, 201 U.S. 43 at 74. U.S. Supreme Court, repeated on page 57. One of the objectives of business trust is to obtain for the trust associates most of the advantages of corporations without the authority of any legislative act and with the freedom from the restrictions and regulations generally imposed by law upon corporations. 13 American Jurisprudence, 2D, page 379, paragraph 51. A trust relationship comes under the realm of equity based upon the common law and is not subject to legislative restrictions, as are corporations and other organizations created by legislative authority. Elliott versus Freeman, 20 U.S. 178. 9. Because assets may be transferred into the PTO and thereby protected, presented, improved upon, and held for the present and future benefit and self and family without negative tax consequences. Market value for the purpose of the Internal Revenue Law is the price at which a seller is willing to sell at fair price, a buyer willing to buy at a fair price, both having reasonable knowledge of the facts in the trade. On the creator's side, the trust certificates received have no reportable or determinable value to be declared. The trust organization receives property at its current market value. If the same property is later sold, only the amount beyond the creator's basis is recognized as taxable, as the appreciated value is part of the trust's assets. The property recognizes that a taxable status exists when transferred into the trust organization, but any tax payment is deferred until distributed from the trust organization to the beneficiaries. American National Bank of St. Joseph versus U.S. 92, Federal Supreme Court 403, 1950. No tax is assessed on the conveyance of property to a trust because it constitutes a tax-free trade and exchange for trust certificates, which have only a contingent future interest of indeterminable value. The tax is not evaded or avoided, it is merely deferred. Brunette versus Logan, 283 U.S. 404. Question. In the case above, the court ruled that the tax is not evaded or avoided. It is merely deferred. Does this mean that taxes are due and payable when a PTO is terminated? The IRS sees taxes as due and payable every time a tax-paying entity receives income. But if another PTO receives the final distribution, according to Diane H. Whitby, Chief Accounting Branch, Internal Revenue Service, Philadelphia, Pennsylvania, a PTO has no tax requirement. Therefore, no taxable event with a tax-paying entity has occurred. Question. Could a PTO be set up to cover profits that have been made in the past? No. A PTO can greatly reduce or eliminate federal income taxes, self-employment taxes, estate taxes, and probate costs, but it can only do so starting from the date of its creation. To attempt to backdate a PTO would put benefits to be derived from it in the future at risk. Can a PTO claim a refund for taxes paid in the past? Only entities that have paid taxes can go back in time to claim a refund. Since a PTO doesn't have any tax requirements, it cannot claim your refund or anyone else's. If a refund is due, you will have to claim it for yourself using your name and your taxpayer identification number and not those of the PTO. How are assets such as cars and boats transferred into a PTO? Sometimes it is best to leave assets such as cars and boats titled in the name of an individual, but in exchange of the equity with the PTO and I'm sorry. Sometimes it is best to leave assets such as a car and boats titled in the name of an individual, but to exchange all of the equity with the PTO and have the PTO record a responding security interest in the asset using a demand note and UCC1. The interest would have to be satisfied and released by the PTO before the title could be transferred to anyone, though. This would protect the individual in terms of liability because if an individual has no equity in a property, no equities can be seized from or taken by way of judgment against the individual. The individual meaning your straw man, guys, okay? If the legality of my PTO is challenged, who can I talk to? Although no instance in the past is known where the validity of a PTO has been challenged in court by the IRS, there are several persons who offer assistance in the realm of PTOs and your common law rights. There are both non-lawyers, persons who have graduated from law school but who do not wish to join a bar association, and then lawyers. Most of these individuals work on a consulting basis with hourly rates of $150 or less. Because its previous attacks were not successful, the IRS does not like to acknowledge the existence of PTOs. It seems like the IRS is making an effort to keep a lid on the spread of PTOs. The tactic of the IRS is not to attack the PTO entity, but to attack the people who promote them. These attacks range from bad mouthing to setting up elaborate sting operations in which the trust promoter has allegedly become involved in money laundering. Wow. Because of these IRS tactics, most lawyers will not consult with any individual who will not sign a statement certifying that he or she is not a government agent and that the asset or income involved have not resulted from illegal activities. Okay. Question: where can I look for additional information about PTOs? A. Answer: Volume 13 of American Jurisprudence, 2nd edition, 1985, examines court rulings that concern a variety of forms of trust operations. PTOs have some of the qualities of the trust organizations that are described in this legal reference work as common law trust, because trust and Massachusetts business trust, I'm sorry, it says PTOs have some of the qualities of the trust organization that are described in this legal reference work as common law trust, business trust, and Massachusetts business trust. In addition, you may study income taxation of trust, estates, grantors, and beneficiaries by Jeffrey N. Pennell, West Publishing Company, or the Federal Tax Guide, Legal Forms 2D. Okay. Question: how does a pure trust organization work for the founder of a fraternal association? Step 1. The founder or trustor of a desired PTO contracts with the creator or protector for an exchange of the founder's trustor's property in return for the right to the final disposition of assets when and if the PTO is ever dissolved. This contract involves a quid pro quo, equal value for equal value, exchange, i.e., real property for the right to any residual assets of the PTO upon dissolution. Step 2. Through the process of the exchange, the creator protector assigns the founder, trustor, or trustor's property to the legal entity called a PTO. In exchange, the founder trustor offers and receives $25 of silver in consideration for 100% of the right to the final distribution of the asset of the PTO whenever and if ever it is dissolved. Okay? The creator protector will then appoint and employ the founder trustee to be the managing trustee of a majority unrelated board of trustees who will administer and direct the affairs of the PTO according to the terms of the PTO. Step 4. The founder trustor designates the beneficiaries of the trust. Okay, so this is how it goes, you guys. This is basically how the pure trust is formed. You have the founder trustor, you have the creator protector who appoints the trustees and managing trustees. You will have your Schedule A, which is your pure trust organization, and then you list your beneficiaries and then subsequent trust names. So you'll have additional trust after you make your pure trust organization. Okay, so I'm going to end the reading for today. Okay, and we're going to pick up on chapter 7 when I come back, and we'll continue reading. It doesn't look like there's much reading even left, guys, because the book actually gets into the creation of the trust. Well, there is reading, but of course, this is just basically you putting together your trust. Okay, so we'll go over that information, and that'll be that. So, guys, how did you guys like the reading today? Oh, now I can't see the chat. Okay, so I can't see the chat now. Oh, there it goes. Thank you. You're very welcome, Mad Max. So, what did you guys think about what we read today in this book, Asset Protection? It was great and I enjoyed it. Thank you, Janique. I think I'm saying it right, Janika Duncan. I hope I'm saying it right. Yes, I enjoyed the reading today myself. Very, very knowledgeable information, lots of great information in these books that we're reading, you guys. Awesome. Thanks, hon. So that concludes today's reading, you guys. If you guys would like to donate, send donations, just reach out to me. I have definitely instructions in the description area of this video, how you can reach out to me, how you can contact me by Facebook, Telegram, or email. Those that have CHIME, you can email, or you can use my email to send me donations by CHIME. Or if you want to send donations by Cash App, you will have to email me, because I myself do not have a Cash App, you guys, but I use my children's or my husband, so I don't like to put their information out there like that. But I will tell you by email or when you contact me. Okay, so I appreciate you guys. I thank you in advance for your support and your love. Again, Freedom Writers is still has more room for more amazing people that want to work together and build community and grow together. So if that is you and you're looking to grow with like-minded people and learn and grow together, we're learning about status correction processes, and we're working together to, do the birth certificate authentication and, so much more that we have in store. Okay, so with that being said, I look forward to having more of my people to join Freedom Riders. This is strictly open to melanated people, you melanated people. I hate to have to do this, but it just has to be that way. I love all people, but we have to have some things for ourselves at the same time. And I realized that I tried to open it up to everyone, and it just didn't work out that way. So I have to protect our community and protect our people from being infiltrated. And then, even though at that point, at that level, I have to protect the indigenous uh, Americans from imposters that look like us at the same time. So even if you are you melanated, um, I'm really looking just to work with people that are indigenous to the Americas. Like, honestly, um, I really don't have a whole lot of knowledge about other countries and working with people in other countries and how to get their paperwork done, although it's all pretty much the same thing. I can kind of give you basic instructions and stuff like that, but as far as details, that's not my level of expertise. And so I have to make this information known because, like, I even have an individual in my community who is kind of difficult for me to assist because of that simple fact. I don't study a whole lot of things outside of America. So, even like I said, even though all of everything is pretty much uh, the same in other countries, the language and wording of your paperwork and things like that are different. So, I really don't have time to study that and look up information. So I highly recommend, if there are people that are outside of the United States or America, whatever, then, I will, like, maybe formulate a group that I'm not going to be running and managing, but I'll put together a group where you guys can come together and, try to figure these things out on your own for yourself. Or, if there are any groups out there where I can refer people to that are helping, their natives in their countries, please let me know so that I can refer those particular people to those organizations that will be more of assistance to them than I can. It's I hurt. It's like, it's sad that I can't provide you information, that I have to turn you away. But at the same time, I can only focus on so many things at one time and do, help so many people. So, with that being said, I appreciate you all listening in. Thank you all for the thumbs up. Thank you for the likes. Thank you for your participation and just listening. And I'm looking forward to continuing to build with you all. So, with that being said, I'm going to go ahead and end the video. I love you all. Peace and love. Islam to everyone. You guys enjoy the rest of your day. And I will see you guys hopefully tomorrow, if not tomorrow, sometime later on this week. And we'll come back and finish up this book, okay? All right. Okay, Max, make sure you email me then. Yep, you can email me or reach out to me on Facebook. All of that is in the description area already. So, with that being said, you guys enjoy the rest of your day. Peace.